how does that play into the scenario if I might be partially responsible for my actions, but there's still an evidence that there's some negligence on the end of the property too?
So in Pennsylvania, when there is a defense of contributory negligence, it's a question that the jury has to ultimately determine. So if the jury were to find that the plaintiff, the injured party, was 50% or more negligent for, and this is in any accident, but it comes into play, probably more often in like a premise liability case than other types of cases. If the jury determines that the injured party, the plaintiff, is more than 50% negligent, there is no recovery. If they're less than 50%, then the award is reduced by their contributory negligence. So take a case, there's $1 million in damages, there's a verdict. Jury comes back and says property owner was negligent, was liable because they knew about this condition, they didn't fix the condition. Okay, so they're 80% responsible, but the plaintiff maybe should have been paying a little more attention, maybe shouldn't, should have been walking instead of running, whatever the facts are. They're 20% responsible for the accident. So then the $1 million award is reduced by 20%.